afternoon. My name is Sherry Setfin. I'm the magistrate for Seminole County. We're going to go ahead and get started today. The way that the process works is we'll call a case. You'll come up to the front. We'll swear in witnesses. The county will provide its testimony and evidence first. You will have an opportunity to ask questions, but not present any evidence or testimony until such time as it's your turn to go. The county will, once it's closed its case, it will then be your opportunity. You will provide any witnesses or evidence that you have. I will make a decision here today. If you are here for the first time and you are found to be in violation, you stand to have a penalty imposed of up to $250 a day. If you're here for a repeat violation, you stand to have a penalty of up to $500 a day imposed if you are found in violation. So please bear with us. We don't always follow the agenda. We have our own little rhyme or reason back here. You will be called in, especially if you were if you were signed in and made sure that you made contact with the county. We're going to go ahead and call the first case, the Dennis M. and Juliet A. Dreger case, 2431 CESM. And we're going to call all the cases at the same time. So after this, we'll do 2434 and then 2435. Okay? And if you'll enter your appearance, please, for the record.
Mark Jones here on behalf of the Dredgers.
Please have a seat. Okay. And Kara, if I can go ahead and swear you in.
Yes, ma'am.
Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Okay.
Officer Hill, Seminole County Sheriff's Office Code Enforcement for East Region. This is case 2431 CESM, Juliet A. Dreggers and Dennis M. Dreggers, located at 2064 Shady Lane in Geneva. Violation charge is Seminole County Land Development Code, Chapter 30, Part 17, Section 30.302, uses permitted. Storage and accessory structures on a vacant parcel is not a permitted use in an RM1 zoning district. My initial inspection was July 19th, 2023, with notice to respondents on July 21st and September 7th, 2023, with compliance dates of August 31st and September 25th, 2023, with follow-up inspections including yesterday. The results of my inspection is the violation of storage and accessory structures on a vacant parcel remains on the subject property. These photos were taken on my initial inspection on July 19, 2023. The left photo depicts shed/garage. The blue arrow points to the boat dock in the back, and then on the right side there is a camper. This photo was taken on the same date. That's the camper that is on the property. These photos were taken on a follow-up inspection on September 6, 2023. This photo was taken on the same day. These photos were taken on September 29th as well. These photos were taken January 5th, 2024. This photo was taken yesterday. The suggested recommendation is based on the testimony and evidence presented in case 2431 CSM. It's determined that the respondents, Juliet A. Dreggers and Dennis M. Dreggers, are the owners of record located at 2064 Shady Lane in Seminole County, in possession or control of the property, and is in violation of Seminole County Land Development Code, Chapter 30, Part 17, Section 30.302, uses permitted. It is further recommended that the special magistrate issue an order for the respondents to correct the violation on or before midnight of July 10th, 2024. In order to correct the violation, the respondents must remove all storage and accessory structures from the property. If the respondents do not comply with the order, a fine of $100 will be imposed for each day the violation continues or is repeated after compliance. So this property is actually an illegal lot split. That's why there's the garage, the boat dock, and then they put a camper out there. There's another property next door to it that was part of the illegal lot split. That case was going to be heard today as well, but there is a new owner, so that case had to be closed out. So part of when it was all one parcel, there was a mobile home, and it was demoed, property was illegally split, and that's why there's accessory structures on 2064. The county is here to explain more about the lot research and the illegal lot split, if you would like to hear from the county.
Okay. And have you had any contact with them whatsoever?
Only with their attorney, Mr. Jones. We did have a meeting back in October with the county planning and zoning and other members of county staff, and it was explained to Mr. Jones on what needed to be done. He said, not a problem, the paperwork is ready to go. I had told Mr. Jones at the time there were 2 deadlines to meet, one for December and one for January, and if they were not met, then I would file it for a hearing. Did not hear anything back until March, when Mr. Jones was asking, is there a hearing date set yet, because they were going to get the paperwork in that week.
Is anyone living in the RV?
Not them I'm aware of. I've been told they kind of might go there on the weekends, but I don't think I've never seen a car out there.
Okay. All right. Would you like to submit your electronic case file into the record as evidence?
Yes, ma'am.
Are there any objections to the electronic case file being submitted? Okay, thank you. Would you like to go ahead?
She done?
Yes, she is.
So they closed their case, I'm doing my tap dance.
You can absolutely have a seat. You don't need to stand.
Of course I have it, I'm gonna pop up
Okay.
and down if I don't stand.
That's fine.
So the Dredgers purchased this property in August of 2020. They did so in a traditional sale. They took a warranty deed, they have title policy, nothing reflected anything about a... Yes, ma'am. Sorry. It's okay. Nothing reflected anything about an illegal lot split. It was just, as far as they bought it as a buyer in due course, it was just a normal purchase of property. They specifically purchased this property because, would you mind putting those pictures back up for me? Thank you. As you can see, it had an established, what's been called a garage boathouse, and then a very nice concrete boathouse down on a canal that leads to the St. Johns River. And they bought this property with the intent of it being their retirement. They were going to convert this garage into a residential dwelling and put a boat in the boathouse and live out their years happily ever after. In 2022, they determined that the roof was in a state that needed repair. They applied for, they received a permit for the roof. It was inspected, finalized, approved. The county's been on that property and seen the roof and approved the structure in its location since the lot split took place, okay? In July of 23, we got the first code violation. And I don't know how the code violation originated. Like most of them, I believe there was a dispute between the 2 neighbors that were hurling things back and forth with one another. Notwithstanding, Ms. Hill's correct. I was engaged late 2023 because I saw the code enforcement notice saying you got to tear these structures down, and that blows my mind. That barn was built in 1967. It has stood without any problem through umpteen named storms and everything. Same thing with the boathouse, and to have it torn down is an injustice. So I said, I'm going to go sit down with the county and see if we can't get this thing worked out. And I did so. We had a very productive meeting. I was very pleased when I left out of there. We had a course of action. We had a plan that would keep the structures in place, and the plan was, as stated, to convert it. Mr. Dredgers went off and had a heart attack. All right, that gave us a little bit of delay in getting things done. When he had recovered, we submitted our application for a permit to convert this thing. I have the plans here if you'd like to take a look at them.
Okay, possibly.
Yeah, you take my word for it. There are engineered plans to convert this thing. Contractor, I've got a permit number. It's permit 24-00003480. We received comments back on that, and we're working through that. it is still our intent to move forward to convert this thing into a residential dwelling. And my understanding after our meeting, and correct me if I'm wrong, Ms. Hill, is we can have a residential structure on there. We're not permitted to have just a barn, okay? So that's why we're converting it. The two other outstanding issues, and this kind of falls on me, I made the decision not to file the variances just yet until we got through the permitting process, because I wanted to see what the cost is going to be on getting this thing done, and if the scales are tipped, it doesn't make sense to do it. It also doesn't make, there's variance process is expensive, it's time consuming, I'm not cheap. So we're balancing all this stuff out. That's where we are. I just want you to understand, we're not sitting on our hands. I've been working in good faith to get this thing compliant, okay? The variances are in fact filled out. I just haven't filed them yet. I'm trying to get it all to hit at one time so that we just plow through and we don't have any issues.
Okay, so let me hear from the county
Sure.
planning department. I think that might clear some stuff up too.
Good afternoon, Megan Zanorsky for the record.
Megan, can I go ahead and swear you in? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
So let me back up a little bit. So roofs aren't routed to zoning for review. Those are strictly a building permit review. So that's why that structure was not brought up in the past, just for your information.
Yep, doesn't matter.
The variance is still going to be required whether the structure is converted to a single-family residence, because the lot was split. The structure does not meet setback requirements, whether it exists as a garage forward or it is converted to a single-family residence. That variance is going to be required. So I would
And
get
I'm sorry to cut you off, but I do understand that, and here's my perspective. I think there's three outcomes here. One, we tear them all down. We don't want to do that. Two, we convert it and still need to get variances. Or three, we don't convert it and we still need variances, right?
Yes, but I think what they're telling you is that you
That's
can't
not-
convert it unless you get the variance.
Agreed.
But the side yard setback is not going to change whether you convert the structure or don't convert the structure.
Agreed.
Right, that's what he said, the third
Agreed.
thing.
I agree with you. What I'm trying to say, there's three things I can do. I can tear it all down. I can get it converted with variances, or I can get variances for it to remain in place.
Correct.
Okay.
So, agreed. So that was what I wanted to get on record, is that the variances are going to need to, whether you convert it or don't convert it. The other option is if you do convert it, you still need a primary residence. This entire property is located in the floodplain, so you are contending with those issues as well. Mobile homes are an option. You have, staff is fully available to you and the property owners to overcome those obstacles, because they are quite.
And that has been contemplated by the property owners. The thing that's hard to swallow and they're still trying to evaluate, I don't know anybody that would rather have a mobile home as opposed to a block home. So we're trying to see if it's possible. If it's possible, that's the route we're going to take.
Understood, but the conversion of the existing structure to the single-family residence is what is probably going to be difficult. So a staff meeting may be in their favor prior to continuing with the permit process, instead of resubmitting engineer drawings.
And I think that's where we're at.
Okay.
I agree.
So how long is the process going to take?
So if they want to schedule a meeting with the appropriate staff members and then engineer drawings and the variance is at least 90 days. This is Kara's case, so I'm not going to step on her toes. But the variance process alone is at least 90 days due to cutoff and legal advertising deadlines. But that's the bare minimum, and then their design professional timelines on top of that.
And we have more than one case where people have come in and said that they're not hearing from their design professional.
Yeah.
So if if everyone continues to work with one another, that's my goal here.
Right, I agree, and I just spoke to the property owner client, and they have said, we'll go ahead and move forward on the variance process if that's what staff in the county would like us to do, but we still are going to hold on to trying to keep these structures in place. Definitely the boathouse on the canal, the other structure, we want to keep it, but we need to properly evaluate it.
Okay, and then, of course, to keep it, though, you do need the variance.
Correct.
So, and I don't mind giving time as long as everyone continues to work with one another. And if we're moving toward that and we get to the date that I've given you and you're still working with one another, then it's fine. When you stop working with one another, you stop talking, and I mean working with one another, I mean you all working with the county, because really, they don't have the time to reach out to every single person and continue to do that. As
Yes,
long as
ma'am.
you all are maintaining the communication, I would like to give 6 months, which would be, not quite 6 months. Our next meeting our December meeting would be December 5th. So I would want you to come into compliance by December 4th. By December 4th, 8 a.m., you're in compliance with all of the things that the county needs you to do in order to achieve the goals that you need to achieve.
Yeah, I think we can do that just through the variance process alone, and whether or not we move forward on the conversion, we would still satisfy the code enforcement violation.
Okay, now,
So,
answer for me, I'm not seeing, and I know that there are, okay, none, let me see. Okay, so if you don't comply by the December 4th date, let me see, December 4th, I'm going to impose a fine of $150 a day. But like I said, as long as you're working with one another, yes,
And
yes,
to be in compliance, there would have to be a primary structure on the property.
yes, absolutely. That's the goal.
But, yes, and that still gives us time to put a mobile home on the property if we had to.
So if we're back here, December 4th, you have your variance, you have all your permits, but you haven't constructed yet, I'm fine with giving continuances as long as we're moving along. It's when you get permits and construction stops, that's going to be a problem. We need you to continue to move forward at all times. And I think you can. I think you probably, if you do everything that they're asking you to do, I think you can do it and even start construction within this time period. You just have to continue to do it. Okay. So I'll go ahead and do that, December 4th by 8 a.m. or $150 fine. Okay, let's go ahead and call the next case, which is 2435 CESM, and I will remind you, Officer Hill, that you're under oath.
Officer Hill, Seminole County Sheriff's Office Code Enforcement, East Region. This is case 2435 CESM, Julia A. Draggers and Dennis M. Draggers, located at 1810 West Osceola Road in Geneva. Violation charge of Seminole County Code, Chapter 95, Section 95.4 is defined in 95.3A rubbish. Now, typically, I do not bring these types of cases before the magistrate, but because due to the last case, I didn't want the Draggers have to go to code board and to special magistrate, and that's why these two are being brought before you today. My initial inspection was January 5th, 2024, with notice to respondent on January 16th, February 2nd, February 27th, and March 18th, 2024, with complaint dates of January 30th, February 16th, March 12th, and April 1st, 2024, with multiple follow-up inspections, including yesterday. The results of my inspection was the violation of rubbish no longer remains on the subject property. These photos were taken my initial inspection on January 5th, 2024. These photos were taken on January 31st, 2024. These photos were taken on the same date. This photo was taken on February 21st, 2024. These photos were taken on March 13th, 2024. Photos were taken on April 24th, 2024. This photo was taken on May 30th, 2024, where I found the property to be in compliance. And this photo was taken yesterday and still in compliance.
Okay, since the property is in compliance, you certainly can give testimony if you want. What I will do in this instance is I will make a finding of fact that a violation did in fact occur on the property, and that there will be no fine assessed, but that there is a violation. That means if this type of violation occurs again on this property or any other property owned by the property owner, that they stand to have a fine of up to $500 a day imposed for each and every day that it continues. But we're in compliance now.
Yes, ma'am.
Would you like to submit the electronic case file into the record?
Yes, ma'am.
Do you have any objections to the electronic case file?
No, but just clarity on that. You said any other violation by this property owner in the county, so if...
Of this type?
Okay, thank you. That's
Of this
just making
type.
sure. I didn't want them to cross paths.
No, of
Okay.
this type, same type of violation, he's on notice for it,
Gotcha.
which means it would be considered a repeat violation.
Understood.
Okay, thank you. Okay, let's move forward with 2434 CESM.
Officer Hill, Seminole County Sheriff's Office Code Enforcement East Region. This is case number 2434 CESM, Juliet A. Dreggers and Dennis M. Dreggers, located at 1810 West Osceola Road in Geneva. Violation charge of Seminole County Land Development Code, Chapter 30, Part 6, Section 30.102, uses permitted, semi-trucks, flatbeds, and other heavy equipment is not a permitted use in an A5 zoning district. My initial inspection was January 5th, 2024, with notice responded on January 16th, February 2nd, February 21st, and March 18th, 2024. Complaint dates were January 30th, February 16th, March 12th, and April 1st, 2024, with multiple follow-up inspections, including yesterday. The results of my inspection of the violation of semi-trucks, flatbeds, and other heavy equipment no longer remain on the subject property.
Okay, would you like to submit your electronic case file into the record as evidence?
Yes, ma'am.
Do you have any objection?
No, ma'am.
Okay, it will be accepted. Do you have any testimony you want to provide?
No, just that the issue here, it obviously has been resolved. There was some short-term parking of this type of equipment on the property. That's no longer taking place. I just want to make it clear, though, that there is some temporary parking. I mean, this is what this gentleman does for a living. He drives big trucks, and he does come home from lunch from time to time, and he parks a truck in the front yard while he eats his lunch and he leaves. But there has not been, to my knowledge, and I've made it clear to him, no overnight parking, no long-term parking of equipment at the property. So I just want the officer to understand, if she drives by and there's a truck out there, you may want to inquire a little further, because it should only be temporarily parked there.
It has not been temporarily parked there. That's a road I travel quite frequently because I have several cases in the Geneva area, and there'll be days that it's parked there for a few days, not just for a stop to pick up supplies or to drop off paperwork or for lunch. The trucks are unoccupied and parked there.
Okay, so this just means, do you have any concerns with the temporary dropping off, pulling in to do lunch? Are those acceptable?
If they're just there for lunch, but they may have been once or twice, but when I go by there, they're unoccupied, sitting there for a few days at a time.
Okay.
I also want to, and this is just informational, part of Mr. Dredger's business, he has, it's similar to dirt operators, where they give tickets for jobs that are completed. So guys will stop by the house to drop off a ticket for him, and the truck's going to be out front. It's temporary. It's not staying there overnight. So that's a part of what he does there, and I don't think there's anything illegal. Now, if they pull up that semi and it stays there for a month, we obviously have a violation, but I don't believe that's what's occurring.
Well, when his daughter had called me and told me that is what they were doing, every time I've seen the trucks out there, they're unoccupied. There's nobody by the mailbox. There's no supplies being picked up at the time that I see them parked there.
So do you observe them over a period of time, or do you just observe them as you drive by? Do you go back?
Yes, I drive by there, like I said, very frequently. I have several cases in the Geneva area, and they will be sitting there for a day or two, and they'll be gone for a day or two, and they'll come back for a day or two. So that's why it's been in and out of compliance a few times, and that's why I was just asking for the order, because I did discuss that with his daughter. And I said, as long as you're in compliance, I'm happy to file the affidavit of compliance prior to hearing. I said, but you got to promise me they're not going to come back. And she said she would call me back with that, and I never heard back.
Okay. So what I'll do is the same here. I'll make a finding of fact that there has in fact been a violation of Seminole County Code, Chapter 30, Part 6, Section 30.102, related to permitted uses in an A5 zoning district. If the violation occurs again, they are not subject to a fine at this time, but will be subject to a repeat violation. If the violation occurs at this location or any other location in the county that is owned by this particular property owner, and it is the violation that is this violation that is being charged here today, I would just encourage you that the temporary stops, I understand that, and I think the county is accepting of that, but they're going to be able to observe things like a truck being parked in the same location unoccupied for several hours. Those are the types of things that are not going to be acceptable. So I would just make sure that I would caution you there. But otherwise, I think we're good. And if you'll come up here for a second. Okay. Thank you. The next case we're going to call 2419 CESM, Daniel Borders.
Afternoon.
Afternoon.
Thanks.
If I can get you both to raise your right hand, do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can have a seat.
Thank you. For the record, name is Vicki Hathaway, Building Inspector for Seminole County Building. This is in regards to case number 2419, Daniel Borders at 9 North Stonegate, Longwood, Florida. Seminole County Code violation of Chapter 40, Appendix A, Section 105.1. The description of the violations is unsecured pool, installation of a sprinkler system without the required permits. The initial inspection took place on 8/18 of '23 when I received a call from Joanne Tamalonis in regards to a phone call she had gotten from a neighbor. Notice to the respondent went out on 8/21 of '23 and 10/3 of '23. Given compliance dates of 8/25/23, 9/15 of '23, 10/17 of '23. Follow-up inspections show the following inspections that were done and also via computer. Results of the inspection, the violation remained on the property. This is a picture of the property appraiser's website showing that Daniel Borders is the property owner. These are notices of the hearings that were posted on the property of 5/30 of '24. Also, the violation at the same time had remained at 6/12 of '24. The violation still continues to go on 4/10 of '24 and 5/30 of '24. And the photo of the unsecured yard that was taken at one point in time on 10/2 of '23 and 10/24 of '23. This is a picture of the irrigation system that was being installed at the time that I was there posting the property, that was taken on 10/2 of '23. And photos taken again on 9/1 of '23 showing the property unsecured on both sides. Photos of the unsecured pool was removed and fencing was taken down on 8/17 of '23. These are the permit systems showing that no permits have been issued for the violations at this point in time. This is a picture of the Seminole County Code, Chapter 40, Appendix A, regarding the permitting process for Daniel Borders. And the recommendation is based on the testimony and the evidence presented in the case in 2419 CESM. It's determined that the respondent is the record owner of the property located at North 9 Stonegate, Longwood, Florida, in Seminole County, as determined by the property appraiser's records, is in possession or control of the property and in violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1. It's further recommended that the special magistrate order the respondent to correct the violation on or before August 7th of 2024. In order to correct the violations, the respondent shall obtain the required permits for the cited violations. If the respondent does not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. The respondent must contact the inspector to verify compliance. This concludes my case.
Okay, if you would let me know, so he needs to secure the pool. So he would need fencing to secure the pool and would need a permit for
Correct.
the fencing.
Correct.
Okay, and then the installation of the sprinkler system was without the required permits?
Correct.
Okay, okay.
With regard to the fencing, the original fencing has been replaced now that work had been completed in the yard. So it is in compliance currently with regards to the length of fence that's supposed to go down to the lake, as well as the unsecured section of the fencing has been reinstalled. What we moved to complete work in the backyard has been put back.
Was there a permit for the fence originally?
There is not a permit for the fence.
I had taken a section of fence out, which is why the neighbor called and described it as unsecured. I just put the same section of fence back in.
What, was the original fence permitted?
No, ma'am.
Okay, so that means that you need a permit for your fence, the one you have.
Okay.
And then that means that you also need a permit for the irrigation.
Okay.
So they're asking August 7th. Our next hearing date is August 22nd. Would you have a problem giving him till August 21st?
I have no problem as long as he's willing to stay in contact with me now, again. And we talked earlier before the meeting.
Yep.
His fence is partially up, but it's not where it needs to be secured for the pool.
Okay,
It is now, and I invite you to come out and inspect at your convenience.
I would love to.
but you would need a permit also,
will.
so
Yes, sir.
you'll need to work on
I will acquire
that.
the necessary permits prior to the next hearing.
Okay, so it's the August hearing. You actually have a little bit more time than that because we have a July hearing, so we would give you till August.
Appreciate
So
it.
August 21st to come into compliance, or $100 a day for each and every day that the violation remains. But like I said, if you're working with the county, we're not going to have an issue. If you come back and need a little bit more time and you give me a legitimate reason and the county says, yes, he's been working with me the whole time, then we won't have a problem.
Understood?
Okay, would you like to submit the electronic case file
I
into
would.
the record? Do you have any objections to the electronic case file being
No, ma'am.
submitted? Okay, thank you.
Thank
We're
you.
done.
Thank you.
Okay. The next case is 2433 CESM. Oh, wait, that one's pulled. So 22103 CESM, Thomas Courtwright.
Are we ready? Okay, for the record, name is Vicki Hathaway with Seminole County Building Division. This is in regards to case number, it's a lien request here for 22103 CESM, Thomas J. Courtwright Jr. at 5675 Deer Path Lane, Sanford, Florida, 32771. Violation Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by the special magistrate on December 8th of 2022, An order was given issuing the respondent a compliance date of March 9th of 2023. On March 9th of 2023, the special magistrate issued an order extending the compliance date to June 7th of 2023. On June 8th of 2023, the special magistrate issued an order extending the compliance date to August 10th of 2023. An affidavit of noncompliance was filed by the inspector after reinspection on August 15th of 2023. On September 14th, 2023, the special magistrate issued an order extending the compliance date to November 17th of 2023. On November 16th, 2023, the special magistrate issued an order extending the compliance date to February 7th, 2024, with a meeting of February 8th of 2024. On February 8th, the special magistrate extended that order of compliance to March 13th with a March deadline of March 14th. On March 13th, 2024, with a meeting of March 14th. On March 14th of 2024, the special magistrate issued an order extending the compliance date to June 12th of 2024 with a meeting of June 13th of 2024. An affidavit of noncompliance was filed after reinspection on June 12th of 2024. The estimated administrative cost to the inspector on this case totals $1,183.67. The estimated administrative cost for the clerk to this case is $642.75. The estimated administrative cost to process this case to date totals $1,826.42 for both the inspector and the clerk. This concludes my presentation.
So I recall this case because of the number of times that it's been before me.
Yes, ma'am.
Is there a holdup again?
Well, I did talk to Mr. Courtwright because we've been working very closely, and as you said, getting contractors to do their job. I have a list here of things, again, as they were submitted yesterday, and I told him he's going to have to come in to extend his time, or else, I mean, we're now at this point in noncompliance. So he's working diligently with his contractor. I'm watching as things come in, taking them to my plans reviewer, saying, is this going to fly? Is it not going to get in? How's it going to happen? So we're kind of both at the mercy of his contractor at this point in time.
Okay, let me go ahead and swear you in. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, so tell me where we are.
So we're in the review process. We're waiting on HVAC and electrical right now. I believe all the structural stuff has been reviewed, and all the data sheets have been turned in. So we're just waiting on a couple pieces of information, and then I believe the permit can finally be issued.
Okay, so how long are we thinking?
I would suggest he's going to, I like to think people will be out of here in 30 days, but I keep getting, I've got 3 sheets here of comments that are being kicked back, and I'm like, this.
3 sheets of comments on.
From our part of reviewing to get through the gatekeeper looking for questions on drawings. This was an established place that he had purchased with these violations on there, not knowing it, and apparently somebody turned him in.
Okay, so
So he's just trying to correct, and at this point, he's gotten all his permits, but this in-law suite that he's trying to get permitted.
Okay, so does 60 days give you heartburn?
It doesn't to me. I've been babysitting this case for 2 years now. So I think at this point in time, if we can get where we need to get with our drawings with his contractor, that's, like I told him, you hire the contractor, I can't police them, you've got to kind of want it more than I do at this point in time. So, I mean, he kind of is at the mercy because things are built. And as you know, trying to go backwards and deconstruct everything is not an easy process. That's why we're here every month.
So I don't mind giving you another continuance till August 21st with all other parts of the initial order to remain intact. But I do want you to see, there's a lot of fees and stuff that have gone into this and a lot of county time that has gone into this. And your contractor is costing you. So I think impressing upon him the severity of this at this point as well, because the county's costs in this case are $1,826. Now, having said that, I realize you didn't create the problem to start with. You bought the problem. And I do appreciate you maintaining your contact with the county at all times, and I know Vicki does. You're probably have become one of her friends at this point.
Probably tired of
It's on
talking to me.
speed dial at this point. I'm like, at this point, you may as well pick the kids up from school.
Right, right. So I think that, maybe if you can talk to your contractor a little bit about what, is hanging out there for you.
Every day, 2 or 3 times
Okay.
a day, emails, phone calls.
He is, because I'm looking at what's coming in, going, this isn't going to fly. You need to go back to him again.
Okay. And, maybe you tell him, look.
And
if
I'm
you-
not a plans
If you
reviewer.
want to receive payment from me, I've got some, I'm facing some pretty serious issues. So, okay, we'll go ahead and continue till August 21st.
Thank you.
Would you like to submit the electronic case file that you have into evidence? Do you have any objections? Okay, we'll go
Thank you.
forward. Thank you.
Mr. Courtwright, here's your other corrections.
Okay, the next case is 2346 CESM Rico Properties.
Properties. Okay.
You'll go ahead and both raise your right hand. Do you solemnly swear or affirm? Solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth? If you could identify yourselves for the record, please.
Okay, I'm Brian Reese, owner of Rico Properties.
I'm Darren Sims. I'm his asset manager. He brought me on board to help expedite this. Wow, this thing's kind of loud.
Okay.
Okay. For the record, name is Vicki Hathaway, building inspector for Seminole County Building. This is in regards to case number 2346 CESM Rico Properties LLP. Brian C. Reese is a registered agent, 2710 Pemberton Drive, Apopka, 32703. Violation charged is Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by the special magistrate on July 13th of 2023, and an order was issued giving the respondent a compliance date of September 15th of 2023. An affidavit of noncompliance was filed by the inspector after reinspection on September 19th of 2023. On November 20th of 2023, the special magistrate issued an amended order extending the compliance date to January 10th of 2024. On January 11th of 2024, the special magistrate issued an amended order extending the compliance date to March 13th of 2024, with a compliance hearing scheduled for March 14th of 2024. On March 14th of 2024, the special magistrate issued an amended order extending the compliance date to June 12th of 2024, with a compliance hearing scheduled for June 13th of 2024. An affidavit of noncompliance was filed after reinspection on June 12th of 2024. The administrative cost for the inspector at this case totals $587.75. The administrative cost for the clerk on this case also totals $519.54. The total administrative cost for this case for both the clerk and the inspector is $1,107.29. Recommendation based on the recommendation, the special magistrate issue an order constituting a lien in the amount of $13,600 for 272 days of noncompliance from September 15th of 2023 through and including June 13th of 2024 at $50 per day, and the fine shall continue to accrue at $50 per day for each day the violation continues or is repeated after June 13th of 2024. This concludes my presentation.
Okay.
To begin with, we had, to refresh your memory, if you don't remember, I bought the building, previous owner, occupant, built a second floor office and a mezzanine, and put 4 carports on the building, 3 on the back and 1 on the side. We have received the permit and has done the work on the second floor, extensive HVAC work, We've had the inspector out there twice. We're down to just getting test and balance and certification, which has happened in Monday, I think.
Yep.
And so all the interior, the mezzanine's all been approved. We're just down to the carports. And where we got kind of delayed is our structural engineer is just backed up, and he just couldn't get, first of all, we got a letter approving it, and we uploaded that. Wasn't enough. We needed to do drawings. So then we had to go back out, and we had to measure every anchor and the spacing and the gauge of the steel and just everything. Now, that's all been done, but it took him quite a while to get it completed. And we have now uploaded it, and it's the permit applications for the three of the four. The fourth one, he could not approve because the anchorage, no, two things were wrong. The anchorage was not acceptable to him, and it encroached into the 5-foot side setback. So immediately I went to the tenant and said, look, we're not going to be able to keep this one up. She wasn't happy. Pearl Pools is the tenant. We demolished it. We took it down. It's off the property. It's gone. And the other three in the back, he has approved them, and we have the drawings
We've
right over
applied
there.
we've applied for all 3 permits.
Yeah, all 3 permits.
Matter of fact, as of this morning, we applied originally Monday. I think Vicki was actually in the office when we made the application. There were some discrepancies that we addressed and had to expedite through the structural engineer. We got those approved, and we got the structural engineer to sign off on them. I've got that letter uploaded. I've applied for all 3 permits, and the only thing we lack is the inspection of those 3 structures, the staircase that we have commissioned to be built. It's a custom staircase, and that's it. We're in really good shape. The thing that we want to impress upon you is we're not sitting still. We're moving forward as rapidly as the engineers and architects will allow us. Another extenuating circumstance would be that Mr. Reese's partner, which is his father, the other partner in the limited liability partnership, passed away. So he's had to deal with the death of his father. He also had hip surgery, so we've been kind of slowed down just a bit. However, we're still moving forward, and we are anticipating getting this done within the 60-day time limit if you were so gracious enough to allow us 60 days.
So have they been working with you?
They have been.
Okay.
We both went out a week after each other in surgery, and he had the unfortunate circumstance that his father passed away. So I'm like, I can understand that.
Okay. Do you have any objections to an extension to August 21st?
I don't. They are currently working on it, and as long as they're working on it and staying in touch with me, I'm happy to work with them and get it done. They're probably just right outside the door.
We're
Okay.
close.
They're very close.
I can smell the finish line.
To not, yeah. I'm like, just ask for 60 days. That's going to at least cover you somewhat.
Okay. Do you want to submit the electronic case file
Yes,
into the
ma'am.
record? Do you have any objection to
No.
the electronic case file? Okay, I'll go ahead and extend your compliance date to August 21st.
Thank you, Your Honor.
Thank you.
Thank you.
Judge.
Next case is 2359 CESM All-Star Assisted Living. You'll both go ahead and raise your right hand and identify yourselves for the record. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes. Hector Morales.
Ilcia Guerra.
Thank you.
Okay, for the record, it's Vicki Hathaway, Building Inspector with Seminole County Building. This is in regards to case number 2359 CESM, All Stars Assisted Living, Inc., Ilsa Guerra Morales at 1131 Westlake Brantley Road, Altamont Springs, Florida, 32724. Violation, Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. On September 14th of 2023, the special magistrate issued an order giving the respondent a compliance date of December 15th of 2023, with a compliance hearing scheduled for January 11th of 2024. An affidavit of noncompliance was filed by the inspector after reinspection on December 15th of 2023. On January 11th of 2024, the special magistrate issued an amended order extending the respondent's compliance date to February 7th of 2024, with a compliance hearing scheduled for February 8th of 2024. On February 8th of 2024, the special magistrate issued a second amended order extending the respondent's compliance date to June 12th of 2024, with a compliance hearing scheduled for June 13th of 2024. An affidavit of noncompliance was filed after reinspection on June 12th of 2024. The administrative cost for the inspector on this case totals $703.75. The administrative cost for the clerk on this case totals $371.43. The total administrative cost for this case for both the clerk and the inspector is $1,075.18. This concludes my presentation.
Okay.
Hello.
Hi.
I just want to recap a little bit what's happened. I bought a facility in December 2022. The structure was there at the time of the purchase. Everything started when neighbors complained about renovation. We changed the carpet and we replaced cabinets and paint. That was all, but the movements called the attention. So I didn't know the facility wasn't in compliance. The facility wasn't, the building was created with no permission. So it took me a while to find the contractor. The contractor came in place. We started working on the fixing. So we hired the engineer, and draw and everything was done. Was a lot of comments, and they went back and forth. The last time the contractor gave me the comment was in May 17, when he asked me to get in contact with Duke Robinson. So every day I was calling and leaving a message until May 24th, when I finally heard one of the comments that was that he is no longer working in the county. So last week I came to the office and trying to get more explanations about what I can do to fix the problem. So I hear a lot of things that are not good news, but I just hear because I'm following all the steps that you asked me to do. And I just don't want to live with the final that is that won't be in compliance. There is no way to be on compliant. So I don't know if there's any exceptions or any rule, since I'm located between county and city, so rules change. So I just want to know what can be done.
She's in an unincorporated county,
She's
correct?
in the county, correct.
Okay.
Yeah, I'd like to say we had an extensive conversation with Megan, so she'll come up and she can give a lot of details, and it'll make sense.
Okay, I'll remind you you're under oath, Megan.
Yes, ma'am. Good afternoon. I met with them last week for an extended period of time. They are in a quite unusual situation. They are in a residentially zoned lot, RC1, but they have a special exception for a 13-bed assisted living facility. So they have a commercial use on a residentially zoned lot. This, should be an existing shed that may or may not have a closed out final for the shed. I'm not sure of the status of the permit for the shed structure itself, but it should be at most a shed, should not be any sort of living quarters for any intents and purposes, which I explained to the applicant. Any changes to the site, because it has a special exception for the assisted living facility, requires an amendment to that special exception and to the site plan for the assisted living facility. And in an accessory dwelling unit, which is what they originally were trying to accomplish, they're not entitled to a guest cottage because that's
Not-
permanent living facilities,
Right.
what they were trying to accomplish. That's not a guest cottage, that's for intermittent and temporary use. They're in quite a conundrum. So I offered them a pre-app, which is the starting point to move forward. They could potentially do an addition if they want to go forward, but this structure, as it is, must be converted back to a shed, if it can be converted back to a shed. I don't know the status of the existing structure because the special exception is voluminous. I provided them all of the documentation for them to take home and review. And if they had questions, they could come back in and talk to a planner that could go through the special exception with them. And if they wanted to proceed with the addition, they would need to go through the process to do so. They are outside of the realm of the 6 or 7 bed that's allowed without the special exception. So they are tied to requiring a site plan and all of the things that go along with that. So if they want to proceed with any sort of owner's living quarters, they must proceed with the site plan, which is going to be an extended time period. In order for them to get into compliance with this structure, they need to get with the building division to find out what the status is of this structure and what it needs to go back to, or if it can exist at all, in order to, because it doesn't meet the side yard setbacks for this zoning district. So we need to figure out what the status is of this structure, get it back to what it is allowed to be as a shed.
Okay. So you have two choices, but you have to make those choices. And so the two choices have extremely different timeframes. So if you were going to go forward with amending your site plan, it obviously is going to take a lot longer than you just determining whether this structure was permitted initially to, and either did meet setbacks at the time or was permitted and allowed.
If I can speak, it was permitted and inspections have been done. However, it failed at frame. And since then, we've not had any inspections done on it. And as I know of, it was completely renovated with the previous owner, possibly.
Right.
I don't know who did it, but it failed at the final the inspection of the frame, which means everything would have to come out of there and then reframe it and re-inspect it. It'd have to pass to meet final building.
So is that just the upper area or is that the lower area?
It's the upper area.
So the lower area, is it permitted to exist? Because it looks to me.
The whole thing is permitted.
So it was constructed together?
Correct.
Okay. Okay.
That's, if I may say,
Yeah.
and that's why.
If I can read?
Let him finish, though.
Okay.
Let me ask.
The reason why we're in this pickle is because that particular building was pre-existing. It looks even prior to the owner when we got it, right? So as the owners of the houses behind us and to the side of us put that complaint, the structure as it is right now is the way that it was originally. The only thing, just to make sure we clarify, that was touched in the inside was paint and cabinetry, and that's
By
it.
you.
By us, yes.
By you,
Right,
yes.
and the rug, because the rug was already there, but we got rid of it. So all we tried to do was just, because
Replace it.
our thought was we could utilize it as like an office, right? But obviously, we can't, through all the, and that's why it's drawn out this long, because when she first came to you, she came with the idea of getting plans and all that done. Unfortunately, during that time, it wasn't caught that it couldn't be done,
Okay.
And I feel that that's where we're at a disadvantage, because we spent money thinking that we could go ahead and convert it, and then more investigation was done, and now we're like at the reality that, okay, due to the setbacks and all the other stuff, we have to put it back to, according to what's saying. But the way you see it is exactly the way we got it.
Okay, so let me get some information on the structure.
Okay, so this was an actual permit that was done for a two-story storage building, was issued on 3/18 of 91, double feed as work started prior to permit being issued, okay? The footer and the slab inspections were approved, but the frame inspection was disapproved. A new permit for this structure will be required per the building official due to the disapproved frame inspection. No other permits apps have been received at this point in time.
So then whoever constructed it continued to do work even after they were told that the inspections had failed. So even though it existed in the manner it existed, it wasn't permitted.
Yeah, but we didn't know.
No, I understand that you didn't know, but that's unfortunately,
Yeah, but this is the third time I'm here. If I would have heard this story the first time, I wouldn't spend the money that is already spent in there. Because just keeping the hope that I'm just following the guide, what to do, I have the hope because he's in Tampa, I'm here, I don't need to have a big place. That was enough for me.
okay, so that is correct. They have been before us
That's true.
2 other
Yes,
times,
yes.
and they weren't stopped.
I've worked very closely with Ilsa.
Yeah,
Okay.
and again, to defense, it's not the inspection's fault, she can explain it the
Okay,
best.
but I also don't know, when this comes to special magistrate,
Okay.
that they're on a residentially zoned lot with a special exception, trying to do an ADU, and that it's, until I have a building permit and actually something to review, I have no way that they're a unicorn in a cow
Right.
pasture.
Right,
Yeah.
right.
Like, this is a 1 in a million situation that I would have no way of knowing. And if the applicants would come in, this is why we have things like lot researches before people buy property. They can
Right.
come in and do the research before they purchase things to get information. What am I dealing with? What's on this? Zoning confirmation letters. We have the tools for people to utilize before they purchase properties for this very reason. What's on it? And they also have things like title searches when they purchase property. So why this wasn't caught on their title search?
Sometimes title searches don't do lien searches or municipal, look into government stuff, so that is possible as well.
Exactly.
And it looks like that's what happened.
It
That
probably
slid
did.
right through. And so that's what we come to the realization on our last visit. And I really appreciate Megan for her insight because, we spent money that we didn't have to, not knowing that at the end of the day, we're running to a dead end.
Right,
There's
so-
nothing we can do because of where the structure was placed.
Well, so for 2 things, you need to make the decision, and it was what I was saying originally. You either have to decide if you're going to try to get this structure permitted back to being just a shed, or you can go through the process to amend your site plan and your conditional use. And like I said originally, 2 very different processes, 2 very different lengths of time to go through those processes. So I think that Megan has given you a lot of information to mull over, and you probably need to decide how you want to approach this with those 2 options and maybe with some more meetings with the county. So what I'd like to do is give you, I'd like to continue your case for 60 days till August 21st. But in that time period, I want you to decide what avenue you're going to take. And if you have decided in that time period which avenue you're going to take and you start that process, that's fine as well. But we'd basically be back here August 21st, and I understand it would really be for a status to find out which avenue you've chosen. And then that will enable me to decide which time period to give you to come into compliance.
In this time frame, are we incurring a cost?
No, you do not incur a fine if I'm continuing it. And so I will continue the case till August 21st. No fines will be imposed. They would be imposed starting August 22nd potentially, which is when the hearing is. If you come back here and they say, they never came in, they never came and talked to me, they didn't do anything, they didn't make any decision whatsoever, that's going to lead me to think that you aren't taking it seriously and you need to have a fine imposed. However, if you will make the decision Vicky and Megan will walk you through the process. You've got to make that call, and you have to make that call based on your financial choices and what is best for you moving forward. You may determine that the longer process and site plan amendment are appropriate for you. And if you do decide that, they're going to help you. They're going to know better how long that process is going to take you. So, no, you are not incurring any fines, and as long as you're working toward compliance, you won't incur any fines.
But at the end, whatever decision we make, we have to pay some penalties for being here?
Not at this time.
Okay.
But if you continue through and you don't follow through, then yes, you will have penalties. Now, there are costs associated with going through this process. Again, I understand that you inherited this process, and I will take that into consideration. But right now, our biggest and most important achievement from everyone is to get into compliance.
Yeah, based on what we've, talking to Megan, the best thing that can happen is for us to put it back. Well, it's a shed, but just put it back originally, so if an inspection goes in, there's no one living, there's nothing there, except for whatever we have as storage.
And like I said, that's a choice you all have to make, and you have really until August 21st to do that, but I do encourage you, if you make the decision before then, in July, then start going through the process, getting the permits you need to get. The 21 days is to help you make that decision, but I encourage you to start the process of coming into compliance. Okay? Do you want to submit the electronic case file into the record? Do you have any objections to the electronic case file that's in front of you being submitted?
No.
Okay, then we'll continue your compliance date to August 21st.
Thank you.
Thank you.
Thank you.
Okay, 2408 CESM, Julian Jimenez. Mr. Jimenez, if you'll raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Okay, for the record, name is Vicky Hathaway, Building Inspector with Seminole County Building. This is in regards to case number 2408 CESM, Julian Jimenez at 105 Sage Street, Altamont Springs, Florida, 32714. Violation charge of Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by the Special Magistrate on March 14th of 2024. An order was issued giving the respondent a compliance date of May 8th of 2024, and a compliance hearing was scheduled for May 9th of 2024. An affidavit of noncompliance was filed by the inspector after reinspection on May 8th of 2024. On May 9th of 2024, an order was issued extending the compliance date to June 12th of 2024. An affidavit of noncompliance was filed by the inspector after reinspection on June 12th of 2024. The administrative cost for the inspector of this case totals $867.70. The administrative cost for the clerk on this case totals $163.80. The total administrative cost for this case for both the clerk and the inspector is $1,031.50. This concludes my presentation.
Mr. Jimenez?
Yes, well, I was here last time. I bought this property, and they flipped the house, and they did all these renovations and changes, and I didn't know. After I bought it, they did it without permits. I was trying to get in hold of the contractor that the last owner paid for all the renovations. Now they're working on getting the permits. They already got the permit for the windows and all this. They said that they only need to schedule the inspection. And the fence, they got the the permit is pending because they
pending.
submit some documents, but they were bad or they were old. So they submitted, I talked to them today, and they said they submitted yesterday.
Okay.
So just,
And so he's been working with you?
He has called me. We've got an AC system that was part of the violation that's been voided out and that's not been touched since it was voided out. The fence is still sitting in PC status, which is plan check, which means it's kicked back to the contractor. When I talked to Mr. Jimenez yesterday, I believe it was yesterday or the day before, I had to tell him, you need to call your contractor and tell them they need
Yeah, I've been
to
calling them.
get busy.
a lot. Sometimes they don't answer. I'm like, keep calling, messages. I leave them voicemails, emails, everything. Because they ask me for questions, I send them right away. As soon as they ask me something, I've been sending them all the information they've been asking. She said, I just spoke with her, like, before I came in, and she said that the permit, it's been, one is done or submitted, and the other one is pending, and she sent the information yesterday. I keep asking her about the AC, and she said that if this permit, the other one was for everything. I don't know. I don't know too much about this, so.
We've got a fence permit, we have a windows and door permit.
Okay.
Windows and doors issued, that's done. But the fence is still sitting in plan check, kicked back to the contractor, and the AC was voided out and it's not been touched. You can't put those together.
Okay, so you need a new AC permit.
Okay, I will tell them as soon as I leave the place, but yeah, because I keep asking her, and she said, oh, I thought everything was in there. I'm like,
Pat, they can
I'm
call
not
me.
the one who knows, so.
So I want you to have more contact with Vicky.
Okay.
I don't want you to leave this just up to your contractor. Yes, it is your contractor, but you're.
Yeah, I know. And it's not even my contractor, that's what the other people paid, and I'm, he got paid for it, so I was like, you need to get it done, because I bought the house like that. I didn't even know after I bought it,
Okay.
so.
So, and I can appreciate that, but as long as somebody is communicating with her and letting her know what's going on.
That's what I've been trying to do, yeah. When I calling them and they don't answer, I call Vicky a couple of times. Sometimes, yeah, it's busy because she don't get the call, so I don't leave voicemail, so I'm trying again, but I call her to ask her how is everything going, because if they don't answer, I try to answer for.
I'm always happy if there's a question by your contractor, they can call me. If I don't have the answer, I'll take it right over to the plans reviewer who is looking at it to let them know this is what we need.
Yeah, I even sent her your phone number, you call her, because I told her.
can email me,
You need to
even.
call them or ask, because.
And if they're not answering you, I suggest you go there. Yeah, I mean, seriously, because this is, you've got to get them to because it's going to ultimately end up falling on you, not them.
Yeah. That's why I come and, I try to be in touch with whoever, because I need to resolve, but.
Okay, so do you have a concern with me giving till August 21st? I don't want to set him up for failure if he hasn't done anything on the AC, or they haven't done anything for him on the AC.
As long as we can get him permitted.
Okay, so I'm going to continue the case till August 21st, but I want to see some real movement. I do appreciate the fact that one of the permits has been issued. I think that that's very helpful, but I want to see some real movement on the AC.
I will, yeah.
And I mean, I'd like to see them both issued by August 21st, but let's keep in contact.
Yeah, I will,
Okay.
definitely.
Thank you.
Would you like to submit the electronic
ma'am.
case file into the record? Do you have any objection to the electronic case file? Okay, we'll accept it into the record. Thank you.
Thank you.
Next case, 2420 CESM, Rachel and Jonathan Eastman.
Okay, for the record, name is Vicki Hathaway, Building Inspector with Seminole County Building. This is in regards to case number 2420 CESM, Rachel and Jonathan Eastman at 2053 Judith Place, Longwood, Florida, 32779. The violation charge is Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by the special magistrate on April 11th of 2024. An order was issued giving the respondent a compliance date of June 12th of 2024 with a meeting date of June 13th of 2024. The total administrative cost for this case for both the clerk and the inspector is $601.16. This concludes my presentation.
The violation is in compliance at this time?
Yes, ma'am.
Okay. Hi there.
Hey, how you doing? Name is Vicky.
I'm like, why are you here?
I know.
Well, he's here probably for the costs, and
Yes.
I understand that. And so he fully complied with you at all times?
Yes, ma'am.
Okay, then I'm going to find that you're in compliance, and I appreciate you being here, and I'm going to not impose any fees or costs against you because you have probably been the least costly to the county today of anyone.
Thank you. Thank you very much.
I appreciate it. Thank you.
All right. See you, Miss Vicky.
Bye. Don't come back here.
Okay, next case, I have a special request, 2370 CESM, Shelley Bawali.
23 CSM.
I have it. Thank you.
Okay, for the record, name is Vicki Hathaway, Building Inspector with Seminole County Building Division. This is a special request in regards to case number 2370 CESM Shelley Boulay, the tenant at CT Corporation System. This is at 3825 Coconut Palm Circle, Oviedo, Florida, 32765. This violation charge was Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by the special magistrate on March 14th of 2024. An order was given to the respondent of a compliance date of May 8th of 2024 with a fine of $100 per day to continue to accrue for each day the violation continues or is repeated after May 8th, 2024. An affidavit of compliance was filed by the inspector after reinspection on April 8th of 2024. An estimated administrative cost to process this case to date were $591.56 for both the inspector and the clerk. On May 9th of 2024, the special magistrate imposed the order imposing the final cost in lien to have the administrative cost for the clerk and the inspector to be paid within 30 days. On May 30th of 2024, a special request was made from the respondent to go before the special magistrate to address the administrative costs. This concludes my presentation.
Okay, if you'll raise your right hand, do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Okay, and if you can state your name for the record, please.
Shelley Buali.
Okay,
Okay, yes, I did come to court. I did not know when I got my air conditioner replaced anything about a permit. And because I had another company that wanted to give me a $14,000 air condition at the time last year, and I said, no, I can't do that. They pulled a permit anyway. They came to put the air condition in, and I was like, no, I did not sign off on this. So I had, my husband had passed away a year before, then I was in and out of the hospital, so my son had a friend that used to work, that retired from the air conditioning business. He says, I have an air conditioning unit, it just does not have a heat pump with it. So he charged me $3,000, he put the air conditioner in, and I find out 6 months later that he did not pull a permit, and that the permit that the other air conditioning company pulled wasn't closed for a while later, until a while later. But they never, closed off on it. So that was the first time I ever knew that I even had to have a permit, because I never had to do that before. So when I got the certified letter, I just, tried to get a permit. I didn't know how to do it. So I came down here, and they told me, what I had to do. So I paid for the permit that day at the code enforcement office. And I got another certified letter that I had to come to court, but I had already come to court, and you gave me an amount of time to pay it, which I paid it right away. I went down to the permit, they had scheduled the inspectors to come out, and I called back and I said, now, what about this hearing that I have to go to on May the 8th? And they said, no, this was not building. I didn't realize that the building department and the code enforcement, that's not anything that I have any knowledge of. So they said, no, you don't have to go because you already paid your permit, the inspectors are out, and you're all good. Then I got a letter saying that I missed that court date, and now I have to pay the cost, the court cost of $591.56. And I'm here because that's what happened. And I would never have missed a date. If I knew that I was supposed to be here, I would be here. And I was misinformed because I called the code enforcement rather than the building department. So I don't know if there's anything that we can do with that or give me an extension, because I just can't come up with $600 in a month.
Okay. So I do recall this case, and I do recall Ms. Bawali responding immediately. And so I do understand that you can make calls and someone might have said you didn't have a reason to be here. And I am going to take that into account. I'm going to go ahead and vacate the order imposing the fines, and so there will be no fines or costs whatsoever on the matter. And I appreciate you being here today.
Thank you very much. I appreciate it.
Thank you.
Thank you.
Okay. I'm going to call, let's go ahead and get 2421 CESM. Let's go ahead and do that one.
Okay.
I don't believe there's a respondent present.
I don't think there is. Okay, for the record, name is Vicki Hathaway, Seminole County Building Inspector for Seminole County Building Division. This is in regards to case number 2421 CESM, Jill A. Kelly Trust for 411 Kentwood Avenue, Sanford, Florida 32771. Violation charge, Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by the Special Magistrate on June 11th of 2024, and an order was issued giving the respondent a compliance date of June 12th of 2024, with a meeting date of June 13th of 2024. An affidavit of noncompliance was filed by the inspector after reinspection on June 12th of 2024. The administrative cost for the inspector on this case totals $640.90. The administrative cost for the clerk on this case totals $110.13. The total administrative cost for this case for both the clerk and the inspector is $751.03. This concludes my presentation.
Okay, I'm going to accept the electronic case file into the record. I'm going to ratify my prior order of April 11th, 2024. I'm going to find that the property owner was properly noticed to be here today and is not present. I'm going to impose administrative costs in the amount of $751.03. And with the ratification of my prior order, the lien will be placed on the property as of today and will continue to accrue against the property each and every day until the violation remains.
Thank you.
Let's call 2424 CESM, Savikia Simpson and Philip Devonish.
Okay. Okay, for the record, name is Vicki Hathaway, Seminole County Building Inspector for Seminole County Building. This is in regards to case number 2424 CESM, Savikia Simpson and Philip Devonish at 520 Lynchfield Avenue, Altamont Springs, Florida 32714. Violation charge, Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by the Special Magistrate on April 11th of 2024 with an order that was issued given the respondents a compliance date of June 12th of 2024 with a meeting of June 13th of 2024. An affidavit of noncompliance was filed by the inspector after reinspection on June 12th of 2024. The administrative cost for the inspector on this case totals $634.68. The administrative cost for the clerk on this case totals $110.13. The total administrative cost for this case and the clerk and the inspector is a total of $744.81. This concludes my presentation.
Okay, I'm going to find that the respondent was properly noticed to be here today and is not present. I'm going to ratify my prior order of April 11th, 2024. I'm going to impose administrative costs, the amount of $744.81. And with the ratification of my prior order, the penalty will be imposed as of today and will accrue against the property for each and every day that the violation remains.
Thank you.
Okay. Now, first, I'm going to call 2423 CESM. That is the case that has the foreclosure action that's been filed in it. And that is IMS Group LLC. So anyone who is here on behalf of this, if you'll come forward on behalf of this case. Okay, I have other individuals who have signed in for this case as well. Okay, can you please come up here? Okay. Okay, sir, can you tell me your name, please, for the record?
Sterling Scott.
Can you tell me your affiliation with the case?
I actually bought the IMS Group, so I actually own the IMS Group now.
Okay, will you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. For the record, name is Vicki Hathaway, Building Inspector with Seminole County Building. This is in regards to case number 2423 CESM, IMS Group LLC, Paul L. Kendrick, Registered Agent, U.S. Bank Trust Company, N.A., Liz Pending, 2005 Tree Fork Lane, Suite number 113, Longwood, Florida, 32750. This is in regards to violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by the Special Magistrate on April 11th of 2024, with an order issued giving the respondent a compliance date of June 12th of 2024 with a meeting date of June 13th of 2024. An affidavit of noncompliance was filed by the inspector after reinspection on June 12th of 2024. The administrative cost for the inspector on this case totals $688.24. The administrative cost for the clerk on this case totals $141.46. The total administrative cost for this case for both the clerk and the inspector is $830.20. This concludes my presentation.
Okay. Can I have the prior order that was entered in this case, please? Yes, sir.
Everything she's saying is totally accurate. We have no issue with that. We'd like to pay the fine, but Unit 113, the only issue I have is Unit 113 is a totally separate unit from Unit 109. So I just want to know what violations do you 113 have? Because there's no construction on 113.
Okay, so this is the case about 113. And we had a prior hearing that occurred on April 16th, or April 11th, I'm sorry, of this year, and we heard the case already. I'm not here today to rehear the case. I will not rehear the case.
Okay.
You have already been found in violation, or IMS group has already been found in violation. And so today, it's to determine whether you are still in violation. And there's been testimony that has been provided by the officer that this property is still in violation. And so I would encourage you to get with the county.
I'm not contesting that.
Okay,
Yeah, I'm not contesting that. No, not at all. I'm
Okay.
just saying I would like to get with the county to pay up the fines and for them to see that 113 is a totally separate unit from 109. That's all.
the problem is with 113 is you have to bring the property into compliance before you can pay the fines. You could pay the administrative costs, but you would have to bring the property into compliance prior to.
Vicky, can I ask a question?
Yes.
What does 113 have to be in compliance with?
I have pictures here. If you want to meet with us after
Yeah.
the meeting or tomorrow, whenever,
Tomorrow will be actually.
we'll be glad to sit down and go over these. This all came from a fire inspection that was done on the buildings.
But the pictures only show 109.
I only have what, I've never been allowed in the
Okay.
building, so I can't tell you what's in there. I'm going off of the photographs that came from fire.
So we could do that tomorrow.
Okay, so you're willing to let Ms. Hathaway on the property?
Of course.
Okay, so in case 2423 CESM IMS Group LLC, I'm going to ratify my prior order of April 11th, 2024. I'm going to, wait a second. We have other individuals that are here to speak on this property. Before we go further, let me find out if you could take a step back and take a seat.
No problem.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, can you state your name for the record and your affiliation with the property?
Bill Shilson, and I represent the Condo Owners Association for the whole building. So the two units in question are 2 out of 7, and they're technically more than half of the entire structure. Up till an hour ago, before I saw this man in here, those units went into foreclosure 2 days ago, and they are up for auction in August. And my intent here was to establish dialogue with you here for whoever the new owners were going to be. This has been a long, sordid story, but now that it seems the plans have changed, I feel compelled to bring some things up.
Well, I'm sorry, sir, but I'm going to interrupt you.
Okay.
You actually, you weren't noticed to be here as part of this case. And I'm now seeing that my order was entered prior to the lis pendens being filed.
Okay.
So my order will attach to the property. And so if it's going up for sale in August and the lis pendens was just filed, then this case must be further along. I don't know whether Seminole County has responded to the foreclosure action, but they would have had to be made part of the foreclosure action because my order was filed prior to the lis pendens being filed. And I do not see where Seminole County is listed as, oh, it was filed in 2023. Wait, I take that back. Okay. All right. So the order may, you may have issues, like I spoke about before, but nonetheless, the Property Owners Association has not been noticed to be here. If you are providing me with your layperson testimony that you would like to provide me with, you can have 3 minutes.
Okay.
If you want to move forward with that. But your testimony will not be accepted as sworn.
That's fine.
And it will be accepted as layperson testimony.
Okay, that's fine. So the violation here and the remedy of it was that the units needed to apply for a change of use. The use of our building is light industrial. What's been going on there for the last couple of years has been a bar and a lounge and drug-friendly rave parties and other things. So when it got visited by literally every authority in the county, paramedics have been there, fire department's been there, sheriff, DEA, building, everybody's been there, which I believe ultimately led to the building department closing it down and saying you need to apply for permits, but in order to apply for the permits, you have to apply for a change of use first. So our collective biggest problem is the change of use to turn these spaces into a bar and a rave and all this other stuff because it's not conducive with our bylaws or the building code. So that's pretty much all I have to say.
Okay. Well, I'm actually going to find that the violation is still in effect, and I'm going to enter or ratify my prior order. So I do appreciate you giving me that background, and I'm assuming that background is the same on the next case as well?
Correct.
Okay. So if you want to have a seat back in the audience, that's completely fine.
Okay.
And Mr. Sterile, if you'll come back up, please.
Thank you.
Mr. Sterile, I will let you know that I do know that you had tried to provide some information related to your ownership of the corporation. I don't have anything evidencing that you have acquired all the assets of this corporation, nor do I have anything, actually what the county has been able to pull does not have you listed as the owner. There is an agent listed, Paul Kendrick, who has received and accepted all of the notices, but I do accept the fact that you are here. So you had to have received the notice somehow.
And I could provide proof of the ownership. That's not an issue.
Okay. And I'm taking you at your sworn testimony that you are the owner of the property, or of the corporation, the LLC. But I am going to go ahead and order that the property is still in violation of my May 11th, 2024 order. I'm going to ratify the requirements set forth in that order. I'm going to find that the county has incurred costs in this matter in the amount of $830.20. I'm going to impose those fees and costs against the property and provide you with 30 days to pay those fees and costs. And if you do not, then they too will be recorded as a lien against the property. And they will accrue, well, they will not accrue, they will stay as the $830.20, but the penalty that has been imposed against the property will accrue on a daily basis until such time as the fine has been paid.
Can I make a statement?
Sure.
The foreclosure will be dealt with before August 13th. I mean, the sale date or whatever. But I just would like to know how is the HOA person is going to say there's been rave parties and there's never been an arrest, never been any...
Sir, that was not taken into consideration as part of my order. My order was imposed on April 11th, 2024.
Okay, that's fine.
Okay.
We good?
Yes, on this case, I'm going to Ms. Hathaway, would you like to submit the electronic case file into the record in this case? Do you have any problems with the electronic case
No.
file? Okay, we will accept that into the record.
And would I be able to, Vicki?
I'm sorry.
Meet with you?
Yes, I'll be glad to come out and inspect.
What day is best for you?
We can talk about that off
Yes.
the record.
Okay,
You need to get my card.
okay.
We're going to go ahead now and call the next case, which is 2422 CESM. This is also your case.
Also his case.
IMS Group LLC.
Okay. For the record, name is Vicki Hathaway, Building Inspector with Seminole County Building Division. This is in regards to case number 2422, CESM IMS Group LLC, Paul L. Kendrick, Registered Agent for U.S. Bank Trust Co., N.A., Liz Pending, at 2005 Tree Fork Lane. This is in regards to suite number 109, Longwood, Florida, 32750. Violation charge, Seminole County Code, Chapter 40, Appendix A, Section 105.1. Constructions without the required permits. This case was originally heard by the special magistrate on April 11th of 2024. An order was issued giving the respondent a compliance date of June 12th of 2024 with a meeting date of June 13th of 2024. An affidavit of noncompliance was filed by the inspector after reinspection on June 12th of 2024. The administrative cost for the inspector on this case totals $688.24. The administrative cost for the clerk on this case is $141.96. The total administrative cost for this case for both the clerk and the inspector is $830.20. This concludes my presentation.
Yes, sir, I'll remind you that you're under oath. Do you have anything to say regarding this matter?
I agree, and we'll pay the fines.
Okay, then I will go ahead and find on, I guess the Liz Pendens covers both cases.
Yes, ma'am.
I'm going to go ahead and find in 2422 CESM IMS Group. I'm going to ratify my prior order dated April 11th, 2024. And so the penalty will begin to accrue as of today and continue each and every day until the violation is corrected. I'm going to impose fines in the amount of $830 costs in the amount of $830.20 to be paid within 30 days. Or it too will be recorded as a lien against the property. Thank you.
That's fine. Thank you.
And I believe that concludes our cases for this afternoon. Thank you.